Okay, welcome back. We are going to continue with Section 5 of the Missouri License Practice Test for the Missouri Prepaid Legal Insurance Exam. Let's get started.
Number 86. Is legal aid services subject to licensing rules?
No, you do not need to be licensed if you are a legal aid service provider. There are certain groups that are exempt from licensing requirements, and that was focused on in your study guide.
Number 87. Can you distribute brochures concerning PPL without a license?
Yes, the key word here is distribute. You can distribute information concerning prepaid legal services without a license. You cannot, however, take action to sign someone up or to quote the specifics of the plan. You have to be licensed for that.
Number 88. If you distribute PPL brochures, what terms can you not discuss unless you are licensed?
We just covered that in the previous question. Yes, you can distribute information, but you cannot discuss terms of the insurance product. Not the cost, not the specific details, anything without a license.
Number 89. If you are only scheduling appointments for someone else to discuss a PPL plan, is it necessary that you be licensed?
No, it is not necessary for you to be licensed. You are simply scheduling appointments for someone that is. Appointment setters do not need licensing.
Number 90. If you choose to market PPL plans over the internet rather than in person, are you subject to the same rules administered by the D of I?
The answer is yes. The rules are always the same. It applies to all types of marketing when you are licensed, whether you market through a text message, an email, a cell phone, whatever the case may be. The rules still apply. You are licensed. You are a licensed insurance producer, and as such, you are governed by the Director of Insurance.
Number 91. If a person has a website for marketing over the internet, what information is required to be listed on the website?
Great question here. You have to have your address, telephone number, contact information, the states that you're authorized to do business or are licensed to do business in. It's the reason why at Legal Shield we have a standardized hub site, and you can't just create your own individual website. You have to go within the Missouri Department of Insurance guidelines, and therefore what Legal Shield has put together for us in the hub site is all encompassing. It meets all of the requirements and prevents us from accidentally being subject to a violation. So, you have to put your address and telephone number in all the states that you're licensed to do business.
Number 92. If a person is applying for a non-resident license and their state does not participate in the NAIC producer database, what certification is required to be submitted with an application?
The certificate that has to be sent is a certification letter stating that you are licensed and you're in good standing in your home state.
Number 93. How old can a certification letter be when presented?
The certification letter has to be dated within the last 6 months in order to remain valid.
Number 94. Are non-resident licensed producers subject to the same rules concerning address changes?
All licensees, regardless of whether or not they are resident producers or non-resident licensed producers, are subject to the exact same rules.
Number 95. Can non-residents be charged a higher license fee than residents?
Non-resident producers are charged the exact same fees as residents. Remember, and this question will be on there in different variations, everything is the same. Resident producer, non-resident producer are governed by the same guidelines, subject to the same rules and regulations, and are all overseen by the Missouri Director of Insurance.
Number 96. What information is displayed on a license when issued?
On your license will be your name, your address, your identification number, and the date of issuance, any lines of authority, and the expiration date of the license.
Number 97. If the D of I has not been informed of an address change, how much is the forfeiture fee that a person can be charged?
The fee for failing to inform the Director of Insurance of an address change is $10 per month. Now remember, with this, you're going to see the same question over and over and over again, sometimes only slightly changed. That is also going to be true on the test.
Number 98. If the D of I issues subpoenas, compel attendance of witnesses, etc., do they also need an attorney's request?
Remember, the Director of Insurance can do whatever they want, whenever they want, including all of the things listed in this question. They may do it without an attorney's request. They have that power. So the answer is no.
Number 99. If a judgment is issued against a person by the D of I, how long do they have to pay before it is issued as a civil judgment?
You have 10 days to pay any kind of judgment assessed against you by the Director of Insurance before it is considered a civil judgment. Now remember, it's 10 days because you are in trouble. That's kind of the general rule of thumb. 30 days to do it if you're not in trouble, 10 days to do it if you are.
Number 100. Are there any fees associated with being listed on the Register of Appointed Insurers of a state?
At this time, there are no fees associated with being listed on the Register of Appointed Insurers in this state.
Number 101. How much time is available for the Register of Appointed Insurers to show changes in insurer's status?
How much time is available? Well, I'll answer that with another question. Are you in trouble? And if not, the answer is 30 days.
Number 102. What personal issues, unrelated to insurance issues, can cause loss or forfeiture of a producer's license?
You can lose your license or be refused a license if you are behind in child support payments and behind in tax liability. So either or both can result in you not being able to get or continue to hold a producer's license in this state.
Number 103. How long is it necessary to maintain a complete record of complaints against an insurer?
3 years is the amount of time that you need to hold and maintain a complete copy of your records. And that's true in most things related to taxes, insurance, any kind of records that you have to keep. 3 years is a general rule of thumb. So if you see a variation of a question like that, the answer is most likely going to be 3 years as far as how long you have to maintain records of any sort.
Number 104. Explain rebates as licensing requirements are concerned.
Rebating is going to be listed all over the test. It's commonly referred to in the pre-PIG legal insurance world as a referral fee. It's offering compensation for referrals who actually make a purchase. So it's also, you cannot pay for a portion of someone's service. You cannot provide them reimbursement for the service as an inducement to get them to purchase. So that is considered rebating, and it is a license law violation.
Number 105. How many matters can a covered person call the attorney firm about?
Unlimited. You can call about whatever you want, whenever you want, and it is unlimited under the plan.
Number 106. Will hit and run charges be covered under Title II motor vehicle?
No. The rule of thumb under the motor vehicle protection is in order for it to be covered as a free benefit, you have to be doing the right thing. You have to be licensed, your car has to be licensed, and you can't be committing any other crimes at the time. So, it will still be covered, but it will be under the fifth benefit, the 25% discount.
Number 107. How many hours of trial defense coverage is a member entitled to?
The answer is 60 hours, although the feedback that I'm getting is that this is not covered so much on the test anymore. But it is 60 hours. They do not go into the expanded plan, so it's important to understand that the answer is 60 hours always for point of reference.
Number 108. Will garnishments be covered under trial defense coverage?
Garnishments are not covered under the trial defense portion of our benefit. If you are sued and you have the service at the time that the incident that caused the lawsuit, if you have our service in place at the time, we will defend you in the lawsuit if it's defensible. But once the lawsuit is settled, the garnishment is not covered under a trial defense portion of our plan.
Number 109. If you utilize the tax coverage, how much time is the initial consultation?
You get 1 hour for the initial consultation if you are named in an audit.
Number 110. If a person was notified of a tax problem before their coverage of a PPL plan, would they be covered by the PPL plan under Title IV?
The answer is no. Why? Because it's pre-existing. Still covered under the fifth benefit, 25% discount, but not covered in full under the fourth benefit, IRS audit protection. You have now concluded video 5 of the Missouri License Practice Test for the Missouri Prepaid Legal License Exam for Missouri. Continue on video 6.